Hello. If anything is crucial in civil litigation, it's evidence. Of course, it's evidence. And while in a regular court case, you can rely on your lawyer to prepare your evidence and to discuss with you and maybe to enlighten you about some weaker points of your evidence, when it comes to small claims court and arbitration and small claims court, it's totally your responsibility, unless you specifically hire a lawyer to review just behind the scenes. Uh, Normally, it's your responsibility to prepare your evidence. And unfortunately, this burden is more often not discharged properly than otherwise. So, what is evidence? It's something then that can prove observable facts, something that is fixed by impartial means, by like on paper, by a photographer, by a videographer, by some recording, uh, mostly on paper, honestly. Uh, Sometimes it's even a thing, but again, I would say 99% it's a paper, a copy of some paper. It's not the emotional expressiveness of it. It's not the level of rage that the story just provokes. The evidence is needed to prove facts. And most of people who do it in a wrong way, they jump to conclusions. They jump to the point of just convincing somebody around because they know the facts. They know the facts as they know them, and they tell their story. But those who listen to that, and particularly a decision maker, a judge or an arbitrator, they don't know the story. And before even sharing the feelings about the story, they have to decide for themselves if they can trust the story, if the facts are reliable. So skipping the factual part by simply just conveying that this happened and that's it, it's not enough. What can be? Well, of course, if there is a legislative act in your favor, specifically stating this, this, and this, that's a good evidence. Provide it. If you already have a judgment or otherwise some sort of judicial document in your favor, of course, provide a copy in a way that the copy is recognized as valid, of course. So it should be a good copy, sometimes a certified copy. In Quebec, notarized documents, specifically made and meant as notarized, also have a very significant evidentiary value. So if you can prove something with a notarized document, it's better than not. Most of the evidence that could be found in a small claims court, in an arbitration case in a small claims court, I mean good evidence, uh, is based on some documents provided by specialists. Started with a bailiff, but it can be an accountant, can be an engineer, can be some inspector, an expert, a doctor, sometimes a priest or imam or a rabbi or some other representative of like recognized religion, for example, if it comes to that part in some specific real situations when it comes to like pain and suffering, it might come to that part. It can be some specific report prepared by somebody or some professional notes or bank statement also comes in there, or some invoice and so forth and so forth. some document just attesting that some work was done at a certain point by a certain organization at a certain price, something like that. Written statements intended to be an evidence or not, but again, it's better than nothing. Just copies of emails, text messages, maybe some phone calls recordings, some other recordings, something downloaded from the internet, some screenshots, and so forth and so forth. Again, which is on paper in the sense that it can be printed on paper, even if it's an electronic form. Lower level, but still certain level of credibility comes with a testimony of those people who are not interested in the result. Still, the fact that you bring them adds a certain sense of doubt. Like, well, those people, for whatever reason, they preferred to come and help you. Maybe there is some kind of relationship. But still, the longer the relationship distance between you and those people, the better for testimony. For example, if it comes to some, school situation, a teacher from that school might be a good source, or administrator of that school, or some like beauty salon or something like that. Well, police officer, of course. Maybe some plumber, some electrician, if they don't want to deliver some written statement, at least they can attest to what they had done or didn't do. Something like that. Less your friends and neighbors. But again, their testimony is better than yours because they are other people. So their impartiality is more presumed in a way. And the last source is your own testimony, even if it's coherent and very much credible and very much clear and emotional. But if it's not supported by above-mentioned facts, like those we already discussed, it's still just your story. What is called like he said, she said, right? So if you wish not simply to complain and make somebody's life harder, but just you wish to actually, in good faith, go to small claims court or arbitration with an evidence, verify. The steps are like that. Like, first, you put down in writing your story. Don't expect that, as you know all the facts, you will easily just convey your message. Again, those who are not there might not be able to follow when you jump from one fact to another and then back and then add some clarifications and so forth. So put it down so that you see the whole story. Very often at this stage already you see some like weak points or like blank spots or just something missing or even not plausible sometimes. So either you drop it at this stage or you just work on your story. You make it coherent. Then when you have the whole story, you can just outline the facts, not the perception of the facts, not the conclusions on the facts, not the assessment, but the facts themselves that are critical for the whole story to be plausible. So if this ever happened, okay, we can go to next stage. So what do I have to prove that this ever happened? Starting with like some small and stupid things, like, okay, well, I bought a car. Can you prove that you bought a car at that date from that person for this amount of money if you bought it? I just fell there because of that. Fact that you fell, fact that you suffered there at that time, how you prove that. And again, the fact that the very same day you complained about that to your aunt, it's usually, well, better than nothing, but not entirely enough. So, did you contact a doctor? Is there a letter from a doctor? Is there any prescription? Is there any invoice or receipt for just actually buying that prescription? Because if you suffered, probably you needed that medication. If there was some sort of emotional back and forth and fight, again, if there were any body marks, how they were fixed, maybe photos. What is the proof that the photos were actually taken on that date at that place and that the skin we can see on a photo is actually yours? Normally, you'd require an affidavit of the person who took the pictures or was there. Or at least some kind of a testimony to that effect. Maybe you bought a coffee machine and then it stopped working. So again, receipts. And if you think that some additional warranty was offered as a marketing strategy on the website, so do you have a screenshot from that website about that? And again, what's the evidence that the screenshot was made then at that time and not later on, and that the promotion was actually enforced at that time? Of course, when it comes to consumer protection, the burden of proof is attenuated, but still there is. You have to prove basic facts. So you verify the story, you just make a list of critical facts, and then against each of them, you verify if you have anything to actually prove that that happened. And some argument that, do you think I'm crazy? Why would I come here if it didn't happen? It's not a good evidence. Again, what do you have to prove independently? Fixed by some independent, impartial people, independent, impartial means that that actually happened. Somewhere on the go, you might consider what kind of proof the other party might have against those facts. So we all have a tendency to overvalue our perception. And very often, if something is seemingly that and supports our story, we have a tendency to think that it's enough, that seemingly is enough. But that seemingly inherently has this gap where the other party could squeeze in their evidence that it was not entirely this way, for example. That, yes, you bought this at that place at that time, but it was bought with an information, like a car, for example, that certain part of it was not working properly. And it was listed and it was provided, attached to a contract, for example. And as many people, unfortunately, have a tendency to sign those contracts without even skimming through, like thinking, well, it's just a formality, the other party would know, they will not just break the rules. Well, they might. But you have signed. And going against your signature afterwards, it's harder than just to read before. Or you remember for sure that you had some document, but you could never find it. So there is a chance that the other party has a copy of the document and it states something not entirely as you remember. So just always give that a thought. There might be proof against your facts. And if that happens, what will be your explanation? Why? You say that that person meant it as a gift to you. Why that person left a note on something else to some other person saying that after that guy uses it, I'll give it to you then? So that what will be your explanation to that, for example? And only when you have all these and you verified all that and you diligently and reasonably assess the weaker parts of your story, maybe you did the same exercise for the story of the other party, because normally some sort of defense is provided, at least some documents, some evidence is provided in advance, and you have access to that, to your court file. Only then you can think that your case is ready. Otherwise, there might be some unpleasant surprises. Thank you and have a nice day.